First, it was law, then it was struck down as unconstitutional. Now an appeals court says the new Texas abortion restrictions will stand, and the back and forth might go all the way to the U.S. Supreme Court. A law passed by the Texas legislature this summer requires doctors who perform abortions to have admitting privileges at nearby hospitals. That will bar the procedure at 1/3 of the state's clinics. Monday, a federal judge said that violated a woman's right to abortion access granted in Roe v. Wade. But by late Thursday, a federal appeals court overturned that decision, letting the abortion law stand and go into effect immediately. A policy analyst told USA Today it's a huge sea change. Allowing this kind of law to go into effect during a court case is a very different approach to what we've been seeing in other court cases on the same subject. And that conflict between courts could mean the battle over the law is headed to the Supreme Court. The question is whether Texas attempts to protect a mother's health infringe on rights to abortion access. 4 states have passed a similar requirement for abortion clinic doctors, and all have met legal challenge. But Texas is the only state allowed to implement its new policy while under court review. This is the same law that had its passage delayed by a high-profile filibuster in the spring. Pro-abortion rights demonstrators packed the Texas Capitol, helping Democratic Senator Wendy Davis with a 13-hour filibuster that forced a second special session to pass the new abortion law. But it did eventually pass, and the ongoing legal battle over the issue might not be good for Davis's political ambitions. She's running for governor in a heavily anti-abortion rights state. Her likely opponent, Republican Attorney General Greg Abbott, was the one who asked for an appeals court decision. He said he'd take the fight to the U.S. Supreme Court if that's what it takes. For Newsy, I'm Zach Toombs.